Hi, thank you all for coming. I'm Taylor, and you're here with Arati, and we are just going to get started.
Hi everyone, I'm Arati. Great to be here with you and super excited to be doing this training with my colleague Taylor. We want to start off with a land acknowledgement. We acknowledge that we are on the traditional territory and homelands of California Native peoples. These nations include over 120 federally recognized tribes and many other non-recognized tribes, federally non-recognized tribes that are all culturally diverse. We thank these nations and we keep them in our hearts and thoughts as we, sorry, this thing just went in front of my screen. We keep them in our hearts and thoughts, and as we are in this space today, this week, and every day. And please think about, in addition to, if you do not already know what land you're on, there are several different ways that you can be involved in land use taxes. So please take a look online. There are several spaces that discuss that. There are tribes that work with that, and that can be a way that you can show your support and show your acknowledgement of the lands that you and I are all occupying today.
So I just want to remind everyone, so Family Violence Appellate Project, FF, we are a support center. So if you have cases that you need help with, so you're representing a survivor in a housing case, it doesn't necessarily have to be survivor-centered issue, but if you want support, if you have questions, if you have a family law case and you want questions with that, that is what we're paid to do. So please contact us, and you can do so either of these ways at our email or our phone number. Just let us know a time frame. So this could be like, I'm not sure how a good way is to raise this defense. How do I make sure I don't understand the interactions of these laws? What have you? There's lots of things we support with in housing and family law cases. So please feel free to reach out. That's our job. So I love supporting legal aid attorneys. So hopefully I'll hear from some of you all soon.
Yes, and in addition to providing technical assistance and support, we of course also represent clients on appeal. So if you are interested in referring a case to us, at least for our California office, we do also have a Washington State office. Here's the contact information. Keep in mind, just generally, these reviews take time. We have to review the entire record, which we're going to be talking about today, as well as get a lot of information. And so we always appreciate when we have your support when working with a client to review a case, but these do take time. But here's the information to go ahead and do that. And if you have questions about it, please feel free to reach out. And it's never an issue to just refer us a case. We can always let you know if we think it's likely to succeed on appeal or not. So don't necessarily worry. Sometimes people reach out and they're like, is this a case that you would review, or is this a case that you think would succeed before they refer it to us? And I would suggest just in most cases, just refer it to us and we can always figure it out.
So kind of moving on to the nuts and bolts. So laying your record and post-trial options. So I'm going to start, where'd it go? Polls. I'm going to start with a poll. So what is your role? Are people seeing it? I'm not seeing any answers. Oh, this came out kind of weird. Okay, so this poll is 3 questions that came out all at once. Sorry about that. So the questions I'm asking is, what is your role at your organization? What type of cases do you take? And what is your organization's unlawful detainer practice? So do you do bench trials, jury trials, both? I give it about a second more. It looks like a lot of y'all are answering. I know it's 3 questions, so it takes longer. Sorry, I didn't mean to launch them all at once, but there we go. Okay. So it looks like most of the folks here are attorneys, but we do have some paralegals, non-attorney advocates, and intake workers. And most of y'all help, 67% of y'all help with housing cases. About 22 do family and domestic violence. 3 of you, so 7% of you do both family and DV and housing cases, and 2 of you don't work with clients. And most of you guys do jury and bench trials. Cool. Thanks so much for answering. This does help kind of know our audience and who we were talking to. Sorry, I went too fast now. There we go. So first of all, what is a record and where is it used? Generally, all the documents in the court file and any hearings that can have a transcript from a court reporter or an official electronic recording is the record. And where is it used? So you can use it during your case and trial. This is especially when you have multiple hearings and stuff. It's always good to see what's in front of the court. Any post-hearing motions, and we're going to talk a little bit about post-trial and post-hearing motions at the end of the slides. And where we use them for us the most is with writs and appeal. You need a good record to have a good appeal. And so this is what our training is about, to make sure you can get a good record to support a good decision at the trial court, and also, and if you can't get that good decision, to support a successful appeal.
Yeah, so we're going to talk about, what you can do to make a quote unquote good record, and recognizing that there are a lot of challenges to doing this. So even though we've put this on these things on the slide, it's not to suggest that it's easy or that there aren't strategic considerations that might make some of this difficult. And when we're talking about what a record is, at least in family law cases in particular, it can be incredibly difficult because these cases can go on for years. You can have different judges for different topics, different hearings. But it is incredibly important to know the pleadings and things that have been filed in a different part, perhaps, of the case, or on a different issue in the case, which may not be something that you're representing on, or may have been in front of a different judge, or may have happened at a previous year. Because it can influence. Just as a quick example, we had a case where a client who hadn't been represented in her child support motion put information about how she had been abused. And so when we were helping her on her restraining order appeal, we were able to use the pleadings from that child support portion of the case, even though that was being held in a different situation, and use that as part of the record in her domestic violence case. So I think the 2 points I would make off of this slide are really, when we talk about submitting pleadings is, unfortunately, particularly with the way things are with court reporters and even electronic recording, but also because of judicial discretion in terms of how they run hearings, you cannot rely on being able to get things in through oral testimony or through argument in front of a judge, and count on that being the only way to get it in. I do want to say this thing about the acknowledgement and summary of discussions in chambers or off the record. I recognize that that's tricky and can be risky. Unfortunately, the problem is that if you have an appeal and that was an influential part of the process, you are going to miss out on being able to argue that. So there is a trade-off in some ways, but it really is important to try to get that in as best as you can. And then, the other thing too is to make sure, and this happens particularly, at least in restraining order cases where you might be asking for 10 different things, is to make sure that the issues in your request are addressed, and that if they're not, you've preserved those issues and made sure that the court has set them for a new hearing or made some statement about it or something's being done on it, so that you can just make sure that there's no forfeiture of those issues. Sorry, I'm done.
And so make sure you raise any specific objections for every piece of evidence that's excluded, and ensure the court makes rulings on each objection and note it when it has not. I'll talk a little bit more specifically about this later, but raise specific objections for every piece of your opponent's evidence that should have been excluded, and make sure the court makes rulings on your objections and note when it has not. And ask the court to state its reasons, making specific findings of facts and conclusions of law, particularly where required by statute, and refusal to do so by the court. as a note, a court's failure to rule on objection does not waive the issue on appeal, but it best practice is to obtain a ruling on it on the record regardless. So obtaining specific basis or bases for the trial court's ruling if you make an objection on multiple grounds. So if you object for something on multiple grounds and they don't give the reason for why they overrule your objection, you're not going to know. And if it comes to be an appealable issue, you won't have a good record of that. So make sure you try to get a ruling on all of your objections.
So, this is one piece that I think is important too, that's helpful. And again, this is again thinking about appeal, because even when a court makes a mistake or abuses its discretion at the appellate level, the appellate court is not going to do anything unless you can show that there's prejudicial error. And we'll talk more about that as well. But it's very helpful then to argue that harm and prejudice on the record or as part of your pleadings for the record, so that it's clear then that the court, even though it made a mistake, it was aware of the potential harm of not following the order. So that is just another sort of tip, a way to get that information into the record, because that way you can also show that the trial court knew the potential damage of what it was doing. We're going to talk some more about statements of decision. The other piece too that I think is a little bit different, or maybe something that we don't talk about as much, at least on the family law end, is the findings and order after hearing. I mean, it's called findings and order after hearing. So technically, it should include the court's findings. So what I see sometimes when I see these findings and orders and after hearing, I see important information that I see from the transcript that could have been in the order that's not there. And why this is important is that when an appellate court is looking at a findings and order after hearing, and they're looking at the transcript, the findings and order after hearing is what controls. So there is a belief that the court will have, even if, from a time frame, it doesn't actually happen that way, but there is a belief that the trial court has the right to adjust its reasoning, change its mind, make adjustments to its thought process from what it says on a transcript to what actually is written in a findings and order after hearing. So if the court gives a reason or makes a finding and you don't have it in the court order, you're missing an opportunity there. If that's going to be something that's going to be helpful in terms of indicating to an appellate court that perhaps the court's reasoning was flawed or based on improper criteria or legal error. And then the last piece is more specific to family law as well, is that a lot of orders within the family court context are temporary, right? And that particularly applies in custody and visitation orders. It can be very difficult to get a final order in a custody and visitation matter in particular. You also have to look at any of the orders, what it's the effect of the order and not just the name of the order. So, and we have some resources about if you are trying to get a final order when a court has been making temporary orders, how to do that. But that is in part a strategic consideration as well. I'm done. Next. So challenges to getting a good record. And I will say, just to, just as a caveat, when I do this training just on the family law, this can actually just be 90 minutes because there are so many challenges and there's so many issues here. So this is a bit of a truncated presentation on some of this, but getting to a good record, timing is huge, and that's not just on the family law side at all. Short deadlines, especially if you're talking about, for example, a restraining order or an unlawful detainer, the docket, how many cases are going to be scheduled at a particular time. If you're in a county where they only do restraining orders on a certain day, or they only do it on a morning calendar, or they have same day mediation, your time frame is limited, and judges have so much discretion. We see these situations where judges say, you have 10 minutes to present yours, you have 10 minutes to present yours, right? And that's what makes it even more frustrating, and why it can be really important to get things filed in advance in writing because of that. Particularly on the
question.
Yeah.
We have a question.
If you see a FOIA that doesn't reflect the reasoning, do you recommend drafting a new proposed FOIA and attaching the minute order? Yeah, that can definitely be the case. I mean, I think the thing with the findings in order after hearing that can be a little bit tricky is that, generally the court assigns it. and sometimes it's assigned to the person who made the motion, even though you may want to do it yourself if that's not you. And then there are rules, right? Everybody, even unrepresented folks, have the right to file their own version of the findings in order after hearing, to make objections to what happens. And in family law, what's particularly troubling is how much delay there is, right? Even though there's rules about the fact that they have to be submitted to the other side within a certain time. And if they're not submitted, what I see a lot of times too, for example, is that the one side doesn't submit it. And even though the other side has the opportunity at that point to then file their own, they don't do it. The problem is that, you have to get it in on time, right? Once the judge has signed it, unless you've somehow been cut out of the process, it's difficult to go back and then ask for it to be amended. So I think it depends a little bit on the context, and I'm not sure, what the timing of it is, but definitely you want to make sure that you're on top of the rules on that, involved in the process, draft your own, even if the other side has been tasked with doing that, if you don't trust what they're doing, and if they don't, or if they've written something and you don't agree with it, if they don't rule on your objections or accommodate your objections, submit your own, and make sure you get the language that you need. Again, there's huge challenges with that, obviously, because sometimes then the court wants the transcript, or, it could be the minute order and things like that. But technically, in order to protect yourself on appeal, you want to be going through that process. And yeah, so at family law cases in particular, you're going to have continued appearances in front of that same judge, and concerns about that client's future appearances. You might have multiple judges on the same case at different times, on different issues or on the same issues. So it can be incredibly difficult to make sure that your record is clean and clear. In some cases, in some counties, you only have a couple judges anyway. You might have a pro tem or a commissioner that can be sitting to hear a case, and the timeline to figure out whether that's the right person for you and whether that there should be an objection to that is very short. There's also not a lot of accountability or clear requirements for judges having to read the entire case file, right? Which is why, sometimes you need to resubmit things or reattach things or make sure you're clear what the judge has considered, or get things that are in the case file back in front of the judge again. Go to the next slide.
And
Go ahead.
There's another question in the chat about, first of all, whether or not we're only discussing trials or objections made at trial, or pretrial motions, or that. And generally it's applicable. A lot of what we're saying is applicable to all of this, but a more specific question, and I think you are best at answering, Arati, is in drafting your own example notice of ruling, are you limited by what is in the minute order? How do you introduce other items from the record that the judge did not include in their minute order?
I'm not aware on the family law side that you're limited to the minute order at all. I mean, and if you look at the minute orders from different counties, you can see there's a huge difference from what's there. You're not, if you have something that contradicts the minute order, you may have to argue about that. But particularly if you have the transcript, or if you have some way of demonstrating what the court said, you can put that in there. I'm not aware that you're limited to the minute order, in terms of what the court says. And then as far as, and we are talking about, we're talking about hearings generally. I think it's a little bit different when you're having to file the civil trial rules versus maybe when you're talking about individual law and motion hearings, but we are talking about motions in limine as well, and that type of thing. When we're talking about these cases also, there's an understandable focus on getting what the client is seeking now, and it can sometimes cause us to miss how it later impacts later relief. And again, that is somewhat of a strategy consideration, but it's understandable, right? Because obviously no one wants to have to appeal. Appeal is not ideal. The appellate system is not designed to bring people in, it's designed to keep people out. And so that's not, you in some cases, because of a particular judge, you're just not going to get what you think you're going to get, or that there's particular quirks and things like that, and you're going to have to guard against them. But ultimately, there is especially in the family law side, there's a lot of pressure to concede, to settle, to compromise in favor of getting something you want in the short term. And yet, in a lot of those situations, what that can also do is close off avenues for arguing later on that the court made a mistake. Large caseloads and short deadlines. Again, like I said, a lot of what we're talking about in terms of getting a good record. And I apologize, I just noticed a typo there. Is it's really difficult, particularly in the legal aid context, right? It takes time to write up all these things. It takes time to file everything. It takes time to do this in these deadlines when you have short resources. It takes time when you have these large caseloads. And frankly, even on the private side, it takes money to do all of these things, right? So there is an absolute cost to making sure that you have preserved your record, and it's not easy. And then, of course, the court reporter electronic recordings issue, right? At least in the family law side, there isn't a guarantee of a court reporter. It's very county specific, resource specific. They can give it, take it away. It's not necessarily, even when they do allow it for DVRO hearings, they don't allow it for all DV cases. Not every place is equipped for electronic recordings. We do now have situations where the courtrooms are equipped for electronic recordings and you can request it. In LA, just recently, they have now made it possible for you to request an electronic recording. It's a different situation with housing, so I'll let Taylor talk about that. But ultimately, if you don't have a transcript, whether it's coming from an electronic recording or a court reporter, you are in a very different boat when it comes to challenge on appeal. And that's also why having everything in the pleadings and in writing in other ways outside of that can be critically important.
So to add about the electronic recordings, UDs are special and we can actually have official records from electronic recordings, which is very helpful. If you don't know if your court is electronically recording our hearings, you should find out and try to get them recorded. All of your clients most likely have fee waivers, and so you should, regardless, be able to get those, even if they don't have that electronic recording on, you should be able to get them recorded. If your court isn't set up for electronic recording, maybe some advocacy to get that set up, because that, with those electronic recordings, make appeals possible. And just out of experience, judges that know they're going to be recorded make, more, like we all do when we're being recorded, make more thoughtful decisions and think things out. So making sure those recordings are happening to get those better decisions on the ground, and also preserving your rights to appeal, because without a recording of what went on, the chances of having a successful appeal are very, very slim. Okay, so requirements by statutes in unlawful detainer cases. So most of you all probably know this, but very, very please pay close attention to procedural requirements. Unlawful detainers are special, in that the statutory procedures must be strictly adhered to, including stringent requirements for service, notice, and filing deadlines. These procedural requirements can reverse a case where you don't think it's strong. They can be really great and really helpful on your cases. So please don't forget them. And if your court does not understand the importance of it, make sure you get that on the record, and so you can get that case overturned at a fairly more straightforward appeal. And it's easy to forget because it is so easy to evict folks, but it is the landlord's burden of proving by a preponderance of evidence that at minimum there is an existence of a landlord-tenant relationship, that there was a legal termination of the relationship, which is where most of the case usually lies, and the tenant continuing possession of the premises. And when you have affirmative defenses, make sure you follow the statute's language and making sure you're getting findings and the language you need to support the defense. I have reviewed cases where there could have been a strong case, but the attorney didn't get the findings, didn't get the facts that really supported that defense because they weren't really going through the statutory requirements. So make sure you're going through them step by step in your arguments, in your briefs, and hitting all the elements of those. If needed, ask the court for clarifying questions to ensure that their findings and conclusions of law are clear on the record. When the court does not rule in your favor, the court's findings and language are important for challenging that decision. If you don't get the findings, it's really hard to find that it's really hard for the Court of Appeals to find that the court made any reversible error if you don't really know why they came to that decision. And maybe it wasn't supported by substantial evidence, but they don't know how they got that decision. So even when the court order is in your favor, the underlying findings and language are important for defending any appeals. In my experience, landlords don't appeal very often. It is expensive, but it does happen. So it is important to get those findings, even though you may not get appealed. Having them just helps in case your landlord decides to.
Okay, I'm going to talk a little bit about requirements in family law cases. So, one of the things, and this has been part of the development of family law, including, if you look at bills and things like that have been proposed and policy changes that have happened in the family code, is to actually get in more language in the code section that requires courts to make findings and to have reasons and essentially show their work. And, you see, the word finding itself is in this many sections. Good cause, the words must. You go to the next slide. Shall, and shall is mandatory, right? And it's not permissive. And these are all things, if you can go to the next slide, similar to what, sorry, if you could go to the next slide. And this is similar to what Taylor was saying, you really want to use statute's language to make sure you get the findings and language you need to support your request on appeal, but also to be more clear that the court has that obligation, right? And it can't just sort of make generalized statements about best interest or, burden of proof without doing the extra step that it's required to do by statute in many cases, right? And so just to give some examples, there's statement of reasons is an example of a situation where courts are required to either make findings or to give a specific statement about why it does that. Statement of reasons are required in modification of joint custody, orders requiring counseling, orders varying from guideline support, findings regarding marital standard of living. Findings regarding sole or joint custody or unsupervised visitation. This is one I see a lot where courts are required when there's allegations in front of it about domestic violence to make findings as to why they are ordering unsupervised visitation. They, if the court doesn't make a finding, asking for that finding or making sure you've requested in your pleadings that the court make a finding. Or that, that it has to make a finding if it does go in the direction of, say, the other party's request for unsupervised visitation. So that's particularly important. Next slide.
And I just, Max, does that answer some of your questions you had about getting them to make actual written ruling because there's a question in the chat that says, do y'all have any tips or when the court doesn't issue a ruling from the bench and has written rulings is really vague or lack specific findings? I feel like a lot of the rulings not in our favor are intentionally written to avoid any specifics that can be the form the basis of the appeal.
I mean, I can only speak on the family law side, and that's partially why we're going to talk about a statement of decision that sometimes may be the only solution in those situations. But otherwise, a lot of it is again, it's putting things in writing in advance so that it's part of the record, so that if the court doesn't do it, you either have something to refer to say that you asked, or you have something to refer to on appeal, right? Because again, this is not a perfect situation. If the court's only giving you 15 minutes, you may not even get 2 words out. So, I appreciate that it's not, sort of you have this unlimited time or unlimited opportunities, right? And a lot of this is, again, you're doing the best that you can, right? You're pulling together all of these different strategies and trying to get the best record that you can. There's not going to be a perfect situation. But short of, having to just state it on the record and say it and ask, there's really not much other than, and again, you may have a situation where you have to interrupt, or you have to make sure and say, before we go, or before we take this break, or, the first thing that you say after you introduce yourself. Again, some of that depends on the flow of the courtroom and how your judge works. But that's why, unfortunately, there is such an emphasis on what's in writing, because an appellate court can always go back and say, oh, well, you put it in your thing that they were supposed to do this, or it can show on the transcript that this was part of the request as part of your closing argument, or as the court's making its rulings, you have to, unfortunately, may I interrupt, or if the court, with the court's permission, can I request that the court state whether it's making a finding. And that's why statements of decision have also become important too, because a lot of that stuff that you can't get out at the actual hearing ends up coming out in your request for a statement of decision. So I'm sorry that there's not sort of one specific way, and unfortunately, a lot of this is, for lack of a better word, and no pun intended, trial and error, right? Is having to keep pushing and pushing and pushing, and finding ways to close these little loopholes that trial courts have to get out of, doing what's required either under the statute or making the ultimate ruling that you're looking for.
Thank you. Oh, went too far.
Okay. So moving exhibits into evidence. You will hear in other spaces that this idea of moving is kind of antiquated, that people don't use that word anymore, that it's kind of, actually, reflects sort of like an old way of thinking, that it's really just about admitting, whatever the words you want to use. Okay. The important thing is that we see this over and over and over again. People file pleadings with attachments, and they talk about documents in their arguments. They talk about documents with their witnesses and with people on the stand, and they even identify them. They mark them for identification, and they don't make sure they're admitted. And if it's not admitted, it's not part of the record. So call it getting it admitted into evidence, call it moving the exhibits into evidence. You have to keep track. And this is where, again, one thing that's always particularly difficult in terms of talking about resources, that it's incredibly helpful to have someone with you who can keep track sometimes, because as the person who's actually doing the litigating, you are being bombarded with information and with, being what the judge is looking for and your client is looking for and what the other side is doing, and having someone who can help keep track, or even being able to take a moment and say, can we just take a minute so we can review what's in the record right now, what's already been admitted. I've seen that in transcripts before, having a chart of all the documents that you expect to have admitted in evidence, and make sure you've heard the court say, I've received it, I've received it, I've received it, I've received it, is important. But just, you don't ever want to be in that position where, you've brought this to the court, your witness has talked about it, it's been part of your things, and then ultimately we can't confirm that it's actually part of the record, because there's nothing in the record that confirms that it was actually admitted into evidence. Next slide.
Yes, and there's a question in the chat I'm not quite sure about. It says moving evidence into the record equals admitting, and evidence equals publishing evidence. So by moving it into the record, so admitting it into the record, you're identifying as something that the court relied on to make its decision. By just saying it's evidence, you're not really identifying it as something the court relied on to make its decision. And so that how it doesn't really become a part of the record you can appeal, because you can't say the court had that to make its, relied on it to make its decision. So hopefully that answers the question. If it doesn't, please elaborate more.
Can I add a quick thing to that, Taylor? Sorry
Yes,
to interrupt, but
please.
there is, and I'm not remembering it off the top of my head, but you know, there's like a mnemonic that you can use. I think it's called Opera, but I'm not 100% sure. But there's a mnemonic you can use to sort of take you through the steps of how do you make sure it gets into the record, right? Like you describe it, you mark it for identification, you admit it, you move it into evidence. I don't know what the mnemonic is off the top of my head, so I apologize. I should have that more available. But you know, again, if I don't know if it's necessarily the words that matter, but what really is matters is making sure that the court has recognized that it's an exhibit that it is before it for consideration. You know, that will be part of its consideration when it's making its ruling, right?
And it looks like the question was, is evidence slash publishing evidence? I've never heard the term publishing evidence, so I don't know what it means. I haven't heard that term before. So sorry, I can't answer that question. So make sure you make, when it asking to admit evidence, you make an offer of proof as what evidence will show. And doing so helps you make that ideal record and include any prejudice to your client if the evidence is excluded. This makes it clear on review that the trial court had a chance to really make an informed decision. So if your client is getting evicted because of noise complaints from abuse and your landlord already had a neighbor testify about the noise, and you'd like to call another neighbor to testify about the noise from abuse, to prevent the witness from being excluded on the basis that they will say the same thing as the other neighbor, you may want to make an offer of proof, for example, that the neighbor will testify to the perception of whether the noise was from abuse. And so here, that's an example of kind of an offer of proof to make sure the judge knows what they know so they can make an informed decision on allowing that evidence in or not, or the witness in this case. Oh, there's a question answered. There was a question as, would you share them on, oh my God, I can't say the word, later after you remember it in the shower tomorrow?
Yes, I
never
will. I
remember
will
it.
actually, I'll send Yaseline some things I have. I can send for sure. It's just a also quick reminder too, and maybe this happens more on the family law side than on the housing side for sure. But you know, there is a sort of you know, kind of criticism that on the family law side, you know, the rules of evidence, at least the practice sometimes seems like the rules of evidence don't apply. And not only 100% do they apply, but not knowing them and being on the other side when your opponent or your trial judge knows them and you don't is probably, you know, one of the most humbling things you can experience. So do not, you know, don't let the fact that trial courts themselves may treat their own courtrooms, or even certain opposing counsel may treat the family law process as a little bit of the Wild West, deter you
They
from
do that in
both,
evictions too.
yeah, deter you from both not only knowing the rules of evidence for yourself, but holding others to account on that.
So make sure you make evidentiary objections at or before trial. Failure to object to your opponent's evidence may waive your right to challenge the admissibility on appeal. Anything not objected to and accepted by the trial is considered evidence. Make sure you state the grounds for objecting, because failure to do so makes challenging the ruling on appeal less likely to be successful. So this is because the appellate court will assume the court overruled or made its ruling on the proper basis. So if, for example, you just say objection and the objection is overruled, if you're challenged that, the court will just assume that your objection was overruled on a proper basis. So if you're objecting something because you didn't think it was relevant, but it could have also been hearsay, the court will just assume that the objection would have been hearsay, and the trial court was right, it was not hearsay. So questions are motions in limine used in family law? What are the advantages of disadvantages of filing them?
Great question. All the questions have been really great. Thank you so much. Can you just go to the next slide too while you're
Yes.
motions in limine are absolutely used in family law. I think that they are underutilized. Most of the time, part of the problem is that you don't have a lot of time and the filing deadlines for those things can be difficult. But at the same time, of course, oral motions in limine are also permitted. I think having them in writing is the better practice because it allows you to lay your groundwork, and it's much more helpful on the issue of appeal to have those already in writing and in place. I think sometimes the tricky part with motions in limine is that you'll get courts who will say, "Oh, we'll deal with it when that piece of evidence comes up." And sometimes you have a situation, depending on how your hearing goes, that that piece of evidence somehow never comes up, or it doesn't come up when you think it's going to come up. Or, there are other things that are predicated on getting that piece of evidence in, and you don't know. Oprah, that's probably it, but that's no, that's something different. I think I was thinking of opera, but it's something else. But anyway, sorry, I'm getting distracted. But in terms of motions in limine, I think, again, if your case is predicated on getting a piece of evidence in and you don't have an alternate way of getting in, for example, and then later on the court finds that that evidence cannot be admitted because it waited on the motion in limine, you can sometimes be in a tricky situation. So you have to have a plan A, plan B, plan C. But I do think motions in limine generally are underutilized, and really can be very effective in terms of getting ahead of having to on the spot deal with objections or on the spot deal with issues that a court may want to concerns a court may have about particular evidence. And again, one of the beauties of doing it through a motion in limine again is that you also save some time, right? And when you have a court who may be being very controlling about the amount of time you have or starting to restrict or not really wanting, to spend time on certain issues, that's time that you could be spending with your witness on the stand or other things that you get. So, and the other piece too, I guess I would quickly say is that, I can't remember. I can't credit this properly because I don't remember the person's name, but I've been in, trainings before and, been on the receiving end of trainings, where, I've heard sort of a private attorney talk about how they were in court one time and they were making all these objections. And the judge was basically like, do you want to object or do you want to finish the case? Right. So understandably, it's hard because particularly, you could possibly object to every single thing that comes out of the other person's mouth, and then all you'll be doing is doing objections. And having read those transcripts, it is painful, and it can be disruptive. So there are strategic considerations there as well. But maybe not every leading question is something that you have to object to, but you don't want to miss the big picture things, right? And most of the evidentiary objections we see that I think are problematic are ones where it's sort of whole issues that are not being properly objected to, or documents, or not following through on objections to someone's own documents or issues that have been raised, and not sort of pushing back or confirming what the outcome is on that, so that when it is being reviewed on appeal, it's clear what the status of that document or evidence or issue was for the appellate court. Okay, and again, this raise and preserve all issues on the record, and this is where a statement of decision also can be somewhat helpful. But generally, this is the ultimate problem, right? Is forfeiture, right? Issues that are not raised at the trial court level are generally not able to be raised on appeal. And there's so many ways in which, just by virtue of time, things do not get raised, or things that, those loops do not get closed. And that's why having all of those issues in writing ahead of time is helpful. Having, a plan to speak about them, to get them in, to, get it scheduled for another hearing, something, is pretty important. And having, again, a lot of this is like litigation planning, for which there isn't a lot of time in a lot of legal aid situations, and depending on the type of issue. But a lot of this is about having, a plan A and a plan B and a plan C, right? I put it in my pleading. I'm going to try to say it at the court level. If I can't say it at the court level, then I'm going to ask for a statement of decision, and have your check boxes on that. Next slide.
So just so you know, Arthur, we have 12 minutes left, so I'm gonna start going a little faster.
Sure.
Even remember established prejudice. So even if the trial court is wrong, the appellate courts will generally reverse only if there's a prejudicial error. This is something especially newer attorneys have a hard time when looking at and wanting to assess their cases, looking at, yes, they made the error, but what if it was a prejudicial, and you need to establish that and being able to establish that. So it's prejudicial where it appears a reasonable probable result would favor where it appears reasonably probable a result more favorable to the appellant would have been reached but for the error. So, for example, if you had a defense, like you wanted to use the UD defense, the DV defense, so 1161.3, and your client, the court didn't allow it, and they should have allowed it. It was an error. They should have allowed it. But your landlord had another reason, a way they could have evicted and evicted on that record. The not allowing would likely not be a prejudicial error. The court clearly established on the record that they had another way to get to the final result that they did.
Can I just answer this quick question here about the speaking objection?
Yes, please do.
Yeah, I mean, there's so many ways in which you can't win. So I completely understand that. Generally what you hear when you hear judges talk about this is that, they expect you to say objection and say the evidence code or say what it is. So, objection 352, right? And then if you want to say more, you have to say, you wait for the court to make its ruling, and then you say, Your Honor, may I be heard? And then you explain, right? And they can also say no, but, Your Honor, may I be heard? And that is supposed to be the way that you can say more about it. Obviously, you see attorneys do all kinds of things, and it's technically up to the trial court judge to sort of control how much that's happening or not happening. But generally, that's supposed to be how it's supposed to work, right? You say the objection, code section, or what it is, and then if you want to say more, you have to ask if you can be heard on that. In terms of statements of decision, I think maybe we can go to, do you want to go to the, just go to the benefits one? We'll go to a couple more slides. Let's start there. So we have a template, and I will say it's specific to family law. So it's not a housing one, but the main issue with the statement of decision is that it deals with the doctrine of implied findings. And this is, again, like I said, the appellate court is not designed to bring people in. The appellate system is designed to keep people out. And one of the primary ways that the appellate review process does that is that, the status quo and the trial court decision is presumed to be correct. And so where the trial court is silent, right, there's a presumption that the trial court made all the factual findings necessary to support the judgment, and that the court followed the law. Now, this is why, of course, having language in the statute that says that the court had to make findings in writing or had to state its findings or had to give a statement of reasons or that type of thing, or asking for those things, and then the court not doing them can be particularly important. But generally, if you don't ask for a statement of decision, you don't have a challenge against the doctrine of implied findings. And I will say, though, that we do whole trainings just on statements of decision. Statements of decision are not a panacea for all of the problems that might be happening in a trial court record. We see all the time attorneys request statement of decision, and then what they get back as the statement of decision doesn't address most of what they asked for, and certainly not in the level that they asked for it. But your request for a statement of decision, the statement of decision that comes out, and more importantly, your objections to that statement of decision, if need be, are going to be very important at the appellate level. And that's really what you're trying to do, right? There are some attorneys who will say that the statement of decision can help a trial court change its mind, and that may be possible, right? And that I haven't seen that because we always get things that people want to appeal, right? So maybe it does happen, and so sometimes that can be helpful. But what I see more often is that people ask for a statement of decision, But one, they're not prepared for what their contentions and issues are that they want the court to discuss in the statement of decision. And two, when you look at the actual rules for the statement of decision process, right? There is a process for that, right? The court has a certain number of days by which it has to issue. You have a certain number of days by which you have to file objections. If you don't file those objections and the statement of decision is left as is, you waive those on appeal. So being very clear about what the steps are, reading the court rules of that process, also looking at, in addition to the California Civil Code of Procedure 632, there are some areas where statement of decision is required by statute or can be requested by statute in the family code. You know, knowing what that process is and making sure that it's just, not allowed to stand as is without having gone through the process. Because what I see too many times is that the courts themselves don't do it right. They delay on the statement of decision. They don't issue a proposed statement of decision. They just issue the statement of decision as if it's the final order without any room being allowed for objections, or they don't say anything about objections and that type of thing. But that's what the rules allow for and require. And so you are able to still go ahead and do that, whether the trial court specifically says you're supposed to submit objections by a certain date or any of those kinds of things.
So Arati covered a lot of this already, much more eloquently than I will. But generally in a UD, a court may not, for example, specify the acts it thought substantially violated the lease, or why the landlord had just cause, or how it came to the conclusions. And so you really want to get those, ask for those and have those in the statements of decision. And so you have the facts before it, you have an actual chance to appeal it if they were wrong and if they weren't allowed to make that decision under the law. So I'm going to talk for a minute about verdict forms. It sounds like a lot of you do jury trials, which is great. Admitting I have not done jury trials when my organization was only doing bench trials when I was practicing direct services, but I have appealed a jury decision and such. Generally, there's different types of verdict forms. So the general verdict, there's just no special findings. The jury just goes for the plaintiff or defendant. The special verdict requires the jury to decide the questions of fact. They're required for the plaintiff's cause of action and the defendant's affirmative defense. And the court uses these jury's findings to make the rulings, and then the general verdict with special findings. So here the jury must make specific findings and find in favor of the plaintiff or defendant. It is, in terms of having a good record and having a chance to appeal the decision, really advantageous to have those special verdicts and general verdicts. So that will make it not only that you have a better chance that the jury will follow their findings if you have those special findings, but also if they don't compute, if you had findings that didn't go with the actual order you got, you have a good post-trial motion for that. You can get that verdict gone. And also it has a great advantage if you plan to file affirmative suit. So if you have a finding from a jury that, for example, your landlord discriminated against your client, that special finding could be advantageous to any affirmative suits if you're planning to file them. So generally, just to request special findings, you must do so in writing before arguments and specify the issues or questions of facts that you are requesting. The court has discretion in choosing the form of the verdict. And for the sake of time, we are just going to skip through these post-trial motions. Y'all probably know them, and I've done a fair amount of them before.
There's also a tip sheet that's in there, a link to a tip sheet that's in there that you can take a look at too, that gives some information about deadlines and some other considerations. And we have some more information on our website.
It is a really, really great tip sheet. I use it all the time. One thing to note, the appeal deadlines for UDs are different than limited. I'm assuming most of your UDs are limited. they're different. So make sure you don't just rely on that and look at the appeal deadlines for your type of case you have. Yes, you will get the PowerPoints answering the question. Assessing appealability.
Okay, so I'm just gonna, I think we can actually go to the next one, because I think, standard of review, the main thing to just know about standard of review is that, at least on the family law side, the majority of things are considered abuse of discretion. And that essentially, in its most sort of, uh, the way it's sort of written is that sort of no reasonable judge could make this same decision, but it really does have some more room than that. It's a tough standard for sure, but it's definitely there. There's room there, and there's definitely other considerations. So the fact that family court stuff is abuse of discretion primarily means it's not easy, but it doesn't mean it's impossible. But what's important, I think, about just understanding standard of review is that different pieces, different issues, different mistakes are going to have different standards of review, and each one of those need to be evaluated.
For UDs, a lot of the stuff that I review is substantial evidence, because whether or not any findings of fact are going to be substantial evidence. Okay. And there's a question: is a motion for release from forfeiture 1179 not considered post-trial motion in terms of UD tolling appeals? I don't know that off the top of my head. Sorry, it probably is, but I don't remember it off the top of my head. I have to look that up. Benefits. If your client receives a stay pending appeal, which is hard, it's pretty hard. Some courts are better than the other, but if they do, they can stay in their unit, and they may never have to leave their unit if they appeal and win. You have a chance to reverse the trial court decision, which is always fun. And you have the potential to obtain restitution for your client and create case law. We love case law at FAP. That's kind of why we were founded. Case law really can result in a lot better cases moving forward. Drawbacks. It is a long process, years sometimes. So really make sure your client's in for it, and your client may not stay in the unit. Again, it's hard to get those stay pending appeals, and attorney's fees provisions. Always, always, always make sure you look at the attorney's fees provision. If no stay, how do you overcome mootness? The mootness is there's still a judgment against that person. There's still an eviction judgment against that person, and that still stands even if they don't get that stay pending appeal. And so, yeah. Timing. Timing for UDs, you have, I'm gonna just kind of go through this. You can see that here. It seems slow for UDs, but you have 30 to 90 days depending on how this judgment is served to file your notice of appeal deadline. We have tip sheets on figuring out how to find that deadline, and also on the eviction appeals process. You can find links here, and they're also sent out with materials.
Yeah, and just quickly, you really have to think about what a successful appeal could accomplish. Do you have the necessary record? Understanding most orders are not stayed or completely stayed. And, particularly when we're talking about kids or domestic violence, what's going to be the situation at the time when this appeal is finally heard and any decision comes out. A lot of remedies on appeal generally involve remand to the trial court, which again is its own issue. And so it's very critical to get an outside perspective if you are trial counsel. I think that there can be a lot of considerations for trial counsel not doing their own appeals or doing them in conjunction with somebody else if you are going to do them, simply because it's just very hard to not, if you don't have that outside perspective. And also we have some tip sheets and some information here about deadlines.
And we have reached the end, just on time. If you have any questions, please ask. Otherwise, please feel free to reach out. here's our contact information. I'm happy to answer questions. If you have TAs or questions about specific cases you have, also reach out. That's kind of what we do. So thank you all. You had really awesome questions. I really appreciated y'all as an audience.
Yeah, thank you so much. And sorry we were so short on time, but again, please reach out to us individually if you have questions and for follow-up. For statement of decision, I will say it's the statement of decision training we have is focused on family law, so I'm not sure if it's as helpful, depending on what you're asking for. We do have a training that's posted on our website, but if you want to reach out to us individually, we can talk more about that.